ethnicity is Keyo.
Very well. So I will start you off. If you were to present to us a picture or a poster or a painting of an ideal judge of the Court of Appeal, who is an ideal judge of the Court of Appeal, then you tell us how you fit in that bill. What specialization or skills or talent or knowledge or value that you are going to bring to the Court of Appeal. If you can do that in 5 minutes.
Thank you, Chief Justice. I will probably describe myself, and then at the end of it, I will say that I fit into the bill you have just described. This is about the 30th year of my practice as an advocate. In the course of the 30 years, I have practiced practically at every level of the courts in Kenya, tribunals. I have also practiced internationally. I have practiced at East African Court of Justice. I have appeared before a sports court in UK. I have appeared before the ICC. In terms of what I would bring into the judiciary, what probably distinguishes me, because that's my understanding of the question you've asked, I would say I would bring the cumulative learning I've learned in those about 30 years, both nationally and internationally. I will probably just make reference to a number of what I consider to be frontiers in the practice I've had. I will start with probably the international experiences I've had. I have practiced the sports court in UK, and the outstanding case, with your permission, I will not mention names, but I will just describe the issue that obtained in that case, being that I had a client, I'm just picking one case, the client who was accused of taking performance-enhancing substances for purposes of enhancing his performance in athletics. And around that case, I lost the case, but still the issues that obtained are significant. The first issue was we were contending that the handling of the samples used to incriminate him were not properly handled, including there were about 3 people who handled it. They were not maintained in fridges the way they were supposed to. The courier means that were used to send them to Geneva was not properly done. And so our first contention is that in every probability the samples had been tampered with. The second argument we had was that the substance he was accused of having ingested is a substance that naturally obtains in the body. And the more practice you do and the higher the latitude of your practice, the more the body will generate the substance. And the case was lost by reason of this dichotomy, that there is a way it can be determined whether the performance-enhancing substance is natural or artificial, whether it has been ingested. And because of the limited scientific infrastructure we have in Kenya, we were not able to achieve the type of level they had to contest the scientific report. And so the court disallowed our case on the premises that the report that they had produced using the superior labs that they had not been contested. The second case, which I consider very significant, was a case I handled in the East African Court of Justice in the year 2006. And the issue was that Article 30 and Article 50 of the East African Treaty required that the representatives to the East African Parliament must be elected. What then had happened in Kenya is that the government then had using acclamation sort of in Parliament, speak to the people who are to represent Kenya in the East African Court of Justice. And we filed a challenge saying the acclamation does not fit the definition and the intention of the Article 50 of the East African Treaty. And our argument was that the representation in the East African Parliament should be based on the ratio of the representatives of each political party. After arguing making the presentation, the first thing is we got an injunction to restrain the parliament from convening and from recognizing the Kenyan appointees, the ones who had been chosen by acclamation. And then after substantive hearing, the East African Court, we persuaded the East African Court that indeed what was done in the Kenyan parliament did not amount to election, and so the Kenyan parliament was constrained to conduct proper elections, which gave a proration of the representatives. I take pride, probably improperly, in the fact of having been able to stay the recognition of the Kenyan representatives, staying the conduct of the affairs of the assembly until that issue was resolved, and it took about a year. The last international case I wish to make reference to was the case of the ICC, and the issues were whether the clients I was representing were culpable for crimes against humanity, displacement of population, torture, and other conducts that fall under the inhuman treatment. And the significance of that, probably, Chief Justice and Commissioners, is this: that the court is an hybrid of common law and civil law. CJ, I know you gave me 5 minutes, and I've really liked to make to bring out the significance of that fact. Yeah. Yes. So probably the point I wanted to make then, CJ, on that point is that the pressure that was on my shoulders, the pressure that was on the team I was leading in that court, was the speed with which we were required, or I was required, to appreciate what the civil law brings into the proceedings. And I recall that at the start of those proceedings, every second minute, I was raising objections because I'm used to common law system where you can't bring evidence that was not properly acquired. You can't bring newspapers as evidence. You can't have a judge calling for evidence or calling for witnesses. And eventually I learned that under civil law that is possible, and being an hybrid court that had to be allowed. Now, the point I'm making is the speed with which I needed to learn, and considering how the general progression is we are in a global village, and the fact that most of our jurisprudence now make reference to international legislations, I would want to contend that I would also bring that experience and that variety into the Court of Appeal if you find me deserving of getting into that office. In the Kenyan situation, I have practically, as I already said, I have practically practiced at every level. I have practiced, yes. An ideal judge would be a judge who fits into the bill of the requirements of Article 10, Article 232, and Chapter 6, together with the Bangalore rules. A judge who is measured, who has a good temperament, who is competent, who is diligent, who is disciplined, and who is competent. Yes, and one who is ethical. Yes. Thank you, Chief Justice.